You guys ready? Okay. Good evening and welcome to the Limerick Planning Board meeting for April 1st, 2026. You can stand for the flag salute. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, our first order of business is a public hearing for CIA Salvage 41 Range E Road. Sean, if you want to stand up for just a minute and tell us again what you have there and what your plans are.
Hi, my name is Sean Gerard, CIA Salvage. We're here to renew a conditional use permit for 41 Range E Road, Limerick, Maine.
Okay. So what are you doing there now, Sean?
What am I doing right now?
What are you doing at the property right now? What's the...
Right now, I have 7 or 8 cars, and I'm storing some lumber because I just got divorced, and I want to build a couple houses with it.
Okay, so you have 7, 8 cars. You have some reclaimed lumber. I don't know, what do you call that?
All new lumber, it's not reclaimed, it's not used.
New lumber that...
It's been sitting too long, some of it's rotten, we're gonna get rid of it this summer.
Okay, so there's some lumber on site. Okay.
Chip in, made park mulch.
There's also some other miscellaneous building materials on site.
Yeah,
Okay. And there's some equipment and other stuff there as well, right?
there's an excavator, there's a skid steer.
Yep.
My father's got a Kubota tractor. My father was the primary use of this property. He's 85 years old, goes there every day, and as you saw inside the building, he plays in his garage and does what he wants.
Okay. And you, for the foreseeable future, you plan on doing the same thing at that site, is that correct?
Yes, I do, yeah.
Okay. All right. Anything from the board? Any questions from the board? Okay. All right. Is there anyone from the public that would like to speak? A Roku remote? Okey-dokey. Find it. I'm glad you are, because I am not. Okay.
Should be able to project. This is the town property right here?
No, these are all mine. So I spread
But
out.
he owns it now?
He does.
So it's listed as town of Limerick, but that's,
What are you looking for?
Meryl gave us a packet, right?
Yeah,
Okay.
that's this.
Thank you
And
so much.
There should be one of these.
Yeah.
This, I believe.
I've lost my version of that too.
The final conditions that we amended for him to follow. Okay, that's what I just want to make sure.
No.
so you folks have a copy of what I'm going to be saying, and that is
Okay.
information that says 2026 Limerick Planning Board Public Hearing for 41 Range Road. But I just wanted to make sure you had a copy of it in case you needed it for reference. The other materials, a fair amount of that material is going to be in this PowerPoint that I'm hopeful is going to help enlighten people as to what I'm saying, because I may not be very clear all the time. So good evening. My name is Merrill Farrand. Thank you for the opportunity to share with you my concerns about this conditional use permit renewal. I want to show you this image, which you all saw today. Well, almost all of you saw it today. It's on the fence at 41 Rangy Road. My initial reaction last fall was a great smile, thinking, hey, there's some holiday cheer, Christmas cheer. Since then, and with its continued presence and its unique feature, I think the image is emblematic of Sean and Dennis Gerard's opinion of our community. Is it a statement of FU neighbors, FU Limerick Planning Board, FU Stan Hackett, FU perhaps all of Limerick, or even FU to the people who do comply with their conditional use permit? Not enforcing the conditional use requirements is punishing all those good businesses who work hard to comply with their operational rules. Mr. Gerard first received planning board approval for this conditional use in March of 2020. Reminding you all that this application is only coming before you because the then CEO, Michael Gilpatrick, albeit issued a notice of violation that the property was being utilized at the time, albeit unsanctioned by the town, as a junkyard and unauthorized storage of excessive numbers of unregistered vehicles. And I'm not going to do a lot of history, but I think there's a few new people, and I felt that it was important to say a few basic things about that. The Gerards have argued before you prior to today that the lack of compliance with the March 2020 conditional use permit was because of ongoing legal disputes over the legitimacy of that permit. The irony is, after nearly 6 years, the Gerards are still using the property without compliance with our town ordinance, state statute, and this planning board's conditions for approval. In January of 2025, which is now over a year ago, Mr. Sean Gerard and I, with legal counsel, including Mr. Ordway here, agreed to put our differences aside, and the town agreed to a binding agreement that we had made. You folks, I think some of you have seen that binding agreement. It had 10 requirements of Mr. Gerard, or the property, 8 of which were just reinforcements of the conditional use permit requirements your board issued, but not appearing to be in compliance at the time our agreement was being made. And Mr. Gerard was to complete the terms of this binding agreement by June 1, 2025, but surprise, you can tell that he did not. And I'm not here because I expect you to reinforce this agreement. I don't. I only hope that you'll enforce state law and your prior granted conditional use permit requirements. The town ordinance requires that every 2 years a renewal application for an automobile graveyard and junkyard be submitted. It was only after the CEO's insistence that this renewal application was submitted a few days before it would have the old permit would have expired. I realize you folks know this, but for the general public's knowledge, every application includes a copy of the instructional requirements on how to complete the town's conditional use permit application. Therefore, Mr. Gerard knew what you folks required to review this renewal. So you might be asking, why is that relevant? Well, concerning is the Gerard's lack of providing you with a properly completed application. For example, is the site map of proper detail and specificity to satisfy your application's requirements. And this is page 9 of that instructions and the section about what is supposed to be on the site map. Specifically, the Gerard's application included multiple copies of site plans, which I'll show you in a moment, but you have it in your application packet, from his prior renewal application. One of them at least is dated 2022. And of course, you know that there's inaccurate representations on there. And it fails to address your application's needs. Again, page 9 of your own instructions. The details required of the site map include conditions labeled inclusion of contour intervals, location of outdoor lighting, natural features of the property, outcroppings and tree stands, and condition K, location and type of landscaping. So my question is, isn't it the applicant's responsibility to take these renewals seriously? are you responsible for putting the facts into the record? This is not Mr. Gerard's first time through the process. It's not Mr. Gerard's first time hearing these requirements from your board. So here's one submitted site plan with the containers as being the front fencing. I mean, how out of date is that? And it was never legal anyways because the original permit was the berm, and other issues were still the trees and the plantings that were supposed to be there. But there's very few details on there, plus there's the inaccuracy of the duplex in the front. It only shows the fencing on one side, doesn't show the other berm, doesn't show the other fencing. So it's just wholly inadequate. And this is even more horrid, which basically just shows where your stone walls are. And there were many copies included, so if you got bored on one page, you had another page of that material. Mr. Gerard addressed your section called Standards and Conditions for Approval of the instructions with a copy of his original answers from October 10, 2019. More than 6 years old. How many of these responses are inaccurate representations of the property? Many have been pointed out prior to you folks. And again, I ask you, is Mr. Gerard making a joke of this board and the community? I highlighted the ones that were very obviously not accurate. So for the past 6 years, how compliant with the conditional use permit has CIA and the Gerards been? You're aware of many citations before, and I apologize, that I've brought before you, and I'm not going to tire you with old details. What is important is obviously this conditional use permit renewal and the CIA's compliance with this last issued permit and their compliance with state statutes for junkyards. I'm going to use that as my starting point. So the 2021 Maine Land Use Law booklet, and I believe you all have copies of this one, page 126, details that automobile graveyards and junkyards, in quotes, are kept entirely screened from ordinary view from the highway at all times by natural objects, plantings, or fences, and a permit may not be granted for an automobile graveyard or junkyard established after October 3, 1973. Remember, this was established in 2020, and located within 100 feet of any highway. Mr. Hackett has reported to me that he has reviewed with Mr. Gerard his need to comply with this rule. Yet I can document many occasions with vehicles, equipment, building materials, or scrap materials within the 100-foot zone. This is one image only. You have aerial images in there that are serial images I'll talk about later. You can see what's in the front at different times during the past, well, since June, so we're making it 9 months. So I want to reiterate, all these materials are on 41 Rangy Road property, not the adjacent property at 39 Rangy Road. That's something we started to have a little conversation on the site walk about. That being the prior schoolhouse property, where the Gerards have filled that property with lots of material and equipment, since no restrictions exist there, and I'm not trying to say there were. But if you look closely at the property, and I'm going to reiterate what I said on the site walk because it's important to put it in the documents here, you'll note that equipment and materials are spilling over onto what is 41 Rangy Road property, which is an absolute and additional violation of state statute. For Mr. Gerard's own building permit application for the 39 Rangy Road property, the property line is located 16 feet from the edge of that foundation on the easterly side. Please examine those images carefully and validate my statements about equipment placement in that 100-foot, which maybe you did when you were driving out, or maybe you can do it in some of the aerial images. There's actually in the front of that property, from the entrance to 41 Range Road to his eastern property line, more distance of that is 41 Range Road than 39 Range Road. So my interpretation is nice neighbor, because everyone knows that this is a rule. It's been reinforced with him by Mr. Hackett multiple times. You folks have reinforced it. And he's just trying to find every angle at which to push the envelope. Certainly not trying to please neighbors, abutters, and just the disrespect. Our CEO spoke to Sean Gerard on several occasions this past year, reminding him of the conditional use requirements that included removal of the items in the front of the fencing, paralleling Range Road, the lack of adequate plantings. And we'll talk about that because some of that's improved. The setbacks for both sides of the property, 50 feet on the Carroll side, 60 on the Brulot side. The slope requirements, housekeeping, and other items. And I hope Mr. Hackett will validate that with you tonight. I provided similar information to Mr. Gerard and his attorney, Mr. Ordway, in 2 letters this past summer, with documentation including images further reinforcing permit conditions that had not been fulfilled. So after having 6 years to comply with this permit, what did change the past year? Well, as you can see, some material has been brought in to the site in the front of the property. I don't know where it came from. I actually think that any equipment and materials added to the property represent a greater non-compliance to the property, and I didn't think that you could make anything worse before you got a permit in place that was a valid permit, meaning you satisfied the conditions. But this has been made worse, as you can see in a few moments, in images that I have that go back. So these are Google Earth images, not my own. 2018, before he was cited for the violation, in October 2020, which is after the first permit was issued in March. And you can see that right in there is evidence that he's taken down the berm in the front. There's certainly more material there, and I doubt it all happened before Mr. Gilpatrick gave that NOV, but we'll see other images that I've provided that are all from the past 9 months that will further validate more materials have been added to the property. To me, that sounds or seems to be illegal. Further creating a non-compliance with the conditional use permit. In October of 2025, this is when some fill was added to the front of the property. We looked at that at the end of the walk. Spread over a greater area, extending the flat area that looks like a parking area. That originally, remember, was not authorized, and at the end of the last permit renewal, it was said, and he was reminded not to be doing anything of significance to change the property without board approval. But yet this fill came in. Those are the piles before they're spread, and you can see it spread in this more aerial image. Isn't this a deliberate action? It contradicts the terms of your granted conditional use permit, the section that says specific conditions of approval section. To quote that, any variation from the plans, proposals, and supporting documents and representations, except a change determined by the code enforcement to be a minor change that does not affect approval standards or conditions of approval, is subject to the review and approval of the planning board prior to implementation. End of that quote. Didn't this board remind Sean Gerard prior of this rule, after he put in the first parking area, Didn't you remind them, after you put in the major fill that created the elevated central yard, that fill being that material that came from CIA Route 5, and then even the brulette berm, it was done before asking for approval? Does elevating more of the property imply that the Gerards are trying to contain stormwater runoff on their property? I don't think so. I think the Carroll property is at greatest risk of receiving some of this drainage down to that marsh, which then goes, as you remember from many prior statements, goes across the street to the Goodhue property, Piper Ridge Farm, Alexander property, down to the river and down to Lake Arrowhead. This is a sensitive area. And so containing and following a pollution prevention plan is important. So on or about November 4th of 2025, a portion of the fence blew down. The Gerards did remove that remaining fencing along that border, and they did regrade the area where the riprap 1.1 to 1 slope was, and finally brought the slope into compliance with what the planning board conditions required, that being the 2-to-1 slope. This didn't get originally performed on the corner, southwest corner, which is what the picture on the right is. It was just done last week. And I also think it's important, and you saw it today, but it's in the image on the left, that there's no longer riprap covering that other slope. The riprap is a requirement that was in the SWEP plan, which he was told to comply with whatever his engineering firm provided to you for recommendations for pollution control. I do want to say there's one other shocking thing. Every single time any of this excavation work has been done, no silt fencing has ever been erected for any of the excavation work or for the prior fill placements and the fill spread. And I hope you noticed, because on the first page of, and I didn't have a slide of this, on the first page of the paperwork I gave you, I have a copy of Mr. Gerard's erosion control course certificate. It did expire in 2024. And I'm not aware of any renewal, but I do believe Mr. Sean Gerard may, although he may not be currently certified, he is generally aware of the rules for erosion control with excavation work. I also do believe that Stan has said something about it in the past. The Gerards did plant some shrubs after he finished with that 2-to-1 slope on the majority of that Carroll side. Except on the corner, he still has not shrubbed the corner, which was also part of your permit from before. So still a failure of the permit of prior. Graciously, and I really do mean that, Mr. Sean Gerard invited me to walk the property with he and Stan. That was on November 11th, as you folks heard, or November 18th, as you folks heard during our site walk. And Mr. Gerard asked me what needed to be done to satisfy my concerns, and my answers were very logical. They addressed the planning board's conditional permit requirements and our agreement and nothing more. I did specifically discuss keeping the front of the property clear, establishing the 60-foot setback on the brulette side of the property, proper housekeeping, adequate fire lanes about the buildings, and additionally, the stormwater runoff mitigation was discussed, including the failure to comply with the October 2024 SWPP plan from Stillwater Engineering. I guess I'll come back to that later. Of those concerns shared with Mr. Gerard, only partial effort was made on the setback on the brulette side. You saw the crushed concrete culverts that were partially either moved or crushed during the sidewalk. None of the rest of that 60-foot buffer has been achieved. So if you look, you can see, and I guess I should go this drawing. So this is a surveyor's drawing that Mr. Gerard provided, well, copy to me, I think the last renewal, as well as you folks. The only thing I've done to doctor it, so to speak, would be I measured, utilizing the scale that's on there, where a 60-foot setback line would be, because Mr. Lalonde thought the 50-foot mark was the proper one for the property. So that red line that goes down parallel to the building and the property line is my interpretation of where 60 feet is. Today, during the site walk, Stan said it was inside the furthest out trailer that was out there, of the 3 that were from the building to the property line. So you saw how much material was in that area, and you can see on these images how much material is in that 60-foot buffer that's supposed to be totally clear, as it is on the other side, of any material. Something that's been known since 2020. Today, you have to decide if CIA and Gerards have satisfied the terms of your last renewal. If so, it's a simple renewal tonight. If not, then it's a simple denial of that renewal. A denial will not be my fault. It won't be your fault. It's going to be Mr. Gerard's fault, as he has had plenty of time to become compliant. Mr. Hackett has reminded Mr. Gerard of his deficiencies on multiple occasions. And again, one condition not satisfied obligates a denial of this renewal. And this is an important question I think some people may not understand. Some of you might have had this question, that with all these issues, why hasn't the CEO issued a notice of violation? So this is Mr. Hackett's answer to me. He tells me that he has been unable to issue a formal notice of violation these past 6 years, as the conditional use permit has never been brought into compliance to become, or to make it valid. Therefore, it's never been enforceable. So the lack of having an NOV means nothing to the evidence before you. He couldn't issue one. So I know the lack of that was something that bothered everyone, and why you guys couldn't approach any of this problem before. But he couldn't issue one. Not that there wasn't a violation, just that he could not issue it. Additionally, I want to place into public record that I have provided to the CEO numerous aerial images of the 41 Rangy Road property. That's just one example there. Approximately every 2 weeks since June of 2025, up to this prior week, documenting my observations of the noncompliance. Why did I start that documentation in June? Well, that's when Mr. Gerard failed to comply with our legally binding agreement, and I needed to document these failures if I was going to take them back to court. But I believe these images also help you as a town know details about the property that could be lost to time if they weren't documented. I've also indicated in emails to Mr. Hackett my concerns with equipment and material setbacks. Also, additions of fill to the property and concerns of its origin, lack of plantings, issues with sloping, erosion control, concerns with housekeeping, and a lack of adequate fire lanes. Those are all in emails that Mr. Hackett has. I put a real brief summary somewhere in that packet of the emails up to January, which was when we were supposed to have this site walk. I admit that I didn't refresh that list all the way to now. I also provided a copy of the SWPP plan from the Stillwater engineering firm that was dated October 23rd, 2024, which the CEO stated he never received back in 2024. So that was in 2025 I gave it to him. I believe this board has been copied on most of this material by the CEO, timely to when he received those emails and that information. So my opinion is yes, the town's been notified of ongoing violations on multiple occasions. It's not, there's been no mute issues for such a period of time. All right, now, I know you've all been waiting for really some more material. So this is the important stuff. I think all of it was important, but let's go with this. Number one, these are the additional violations of the conditional use permit that still exist. The lack of 2-to-1 sloping and planting on the southwest border of the property, which was a failure to comply with the conditional use requirement 12 of the findings of facts. A week ago, that sloping was still out of compliance, and now the sloping has been corrected, but the shrubbery has not. 2, a lack of the 60-foot setback on the Brulot side of the junkyard operation, which is a failure to comply with the town ordinance, Article 6, Section E1, and condition number 9 of his approved conditional use permit, as well as a lack of full buffer. That berm does not go to the back of the buildings, and in the original permit, the indications are that whether it was berm, whether it was plantings, whether it was fencing, and mostly it was really the plantings, was to go to the back of the building. That's a failure of condition number 9. And you know, there's something else that was said back, and I have to admit, this was something I didn't realize how extensive the material was behind the building now. So even though I had some aerial images, which I knew some was back there, it's much more extensive than I realized. In prior conversations before this board, the back of the buildings was to be the end of that operation of a junkyard. Now, if you go back to 2020 images from Google Earth that I had up there earlier, that will show you that all the materials have been kept in that area back to the back of the building only. But now you're seeing very extensive material going back from that site, which means the plantings of trees or the berms or any of that cloaking stuff is no longer effective for material that is going further back. At least I don't suffer from it as a person driving by on Rangy Road, but the Brulot property does, the Carroll property does, and I'm sure they would appreciate having less impact. Housekeeping concerns exist. That's the third item of my concerns. This increases the risk for fire spread to neighboring properties. That's where I care, and my wife cares. And it can also put EMS and fire services at risk. These concerns are echoed in an email with the CEO, a copy of which is in your packet tonight. I'm not going to put it up here. These concerns were raised by me to Mr. Gerard's attorney, Mr. Ordway, last summer, with a copy of the CEO's email confirming that that was a lack of compliance because Mr. Ordway felt that everything was adequate. But a email from Mr. Hackett, which is included in your packet, told him it was not adequate. So I believe there's inadequate fire lanes based upon that information on the easterly and southerly portion of the operation. You could not walk around the entire operation. We all turned around in the back of the building and went back to the front, or I shouldn't call it front, to the western side. Even Mr. Gerard's commitment statement says that he will provide and maintain that access in his answers to how he's going to comply to the conditions. So he's failing condition number 5 and number 7. Here is what the fire department report had said: maintain fire lanes, and there's a lack of a Knox box, I guess, to have a key so that the fire department could access if something happened when no one's on the property. That was in this page of the report of what he was going to need to comply with. I mean, it's a 2-page thing that has some requirements. I highlighted the ones that I thought might be problematic. And Mr. Gerard has not complied with erosion control requirements. For example, I've already mentioned the absence of silt fencing during excavation work, the failure to reapply the riprap on the regraded Carroll side slope. This is a failure of compliance with the SWPP plan. He has also destroyed erosion controlling vegetation with his recent addition of fill on or about October 5, 2025. Again, failing to place the silt fencing to control the water runoff and erosion to the Carroll property. He also failed to reseed or revegetate the area disturbed. more egregious, the Gerards have not complied with the construction of a sediment basin. This is to quote Stillwater Engineering from its October 23rd, 2024 report.
Recommendation.
To manage stormwater runoff from the portion of the designated scrap storage area shown on the plan that drains towards Rangy Road, we propose that Mr. Gerard construct a sediment basin on the southwest corner of the site, approximate location shown on the plan. This is a pretty distant view. I did try to hone in on it a little bit. So to manage stormwater runoff from the portion of the designated scrap storage area shown on the plan towards Rangy Road, we propose that Mr. Gerard construct a sediment basin on the southwest corners of the site, approximate locations on the plan to capture and treat runoff. A riprap level lip outlet to the basin will discharge runoff in a sheet flow condition to the existing vegetated buffer strip along the south edge of the property adjacent to Rangy Road. A proposed drainage swale along the west side of the access road will collect runoff from the storage area as it drains down the hill and then parallels the toe of the southern facing riprap slope, ultimately discharging to the sediment basin. This system will effectively address both stormwater quality and quantity concerns from facility activities from the portion of the site that drains to the south. So again, the Stillwater report also references the presence of riprap and vegetation as erosion control measures that has since been removed. So such a sizable deviation from the stormwater pollution prevention plan represents a failure of the board's requirements in permit conditions 6 and 13, and of course, the SWEP plan itself. So you can see that the bottom of where the swale is supposed to go, that's all been filled in and is level with the area that I'm going to call it a parking area. If you go back here, I guess it's not just me calling it that. Stillwater said trailer storage area, trailer parking area. I can't read it because my print's too small here. I don't know if that can be seen. You can actually try and see it. But he calls it a trailer storage area. So someone thinks that this is a parking area, even though it's supposed to be a clear zone. But he's extended that. And as you can see, this sediment basin is supposed to really start at the base of that slope. And as you walked it today, I know some of you went over that far, you can see that the area of opening that potentially could represent some sort of collection area. I said potentially, because he's way above, or it's way above, the level of what the ground was before when this original plan was done, which means the SWEP plan is really invalid anyways, because he's supposed to get a new plan every time there's been a major disturbance. But that sediment basin is supposed to be a little bit more northerly than where he has an opening right now on the property. And then it's supposed to have that proper drainage level so that once it's filled, anything that overages comes gently out, goes across his property, not directly into the Carroll property. And everyone today probably saw the erosion that's there on that disturbed ground from last fall's efforts. And you can even see it in the aerial picture that how water is running and not properly controlled. Again, just one violation of the conditional use permit is all that's required to deny this renewal. I recited at least 6 areas of violation of either the conditional use, ordinance, or state statute. There would have been, if things didn't start just last November, more. Until one day last week, there had been no activity since November 30th. Although I have to correct that. He removed the equipment and materials and vehicles from the front of the property in the week before your first scheduled site walk in January. Interestingly, I also question why there's such a large area still to the left of that driveway. I'm going to say it over and over again. That's not supposed to be a parking area. No materials are supposed to be dropped there. But it's been plowed all winter, or much of the winter. Looks like they're really thinking of keeping that area open for all potentials. Whatever your decision, please remember the words of Attorney Ordway. And I have that in one of the, in the packet. I have a copy of part of a legal statement that he made to this board prior that I just took out of there because I thought it was important. So remember these words in a prior correspondence where he cited the planning board's prior inadequate documentation of its findings of fact. Because an approval or denial of this permit requires very specific details to protect the integrity of your decision. Please review that letter, or that little portion that I copied, and I'm sure he would provide much more material if you requested it. But protect your decision, allow the CEO to have good material to make whatever basis of decisioning he has to do. It's also important for appeal board review or for a court appeal. Please consider these violations seriously. There are adequate reason to deny renewal. Small last-minute efforts are not compliance with your granted permit. It's been a pattern of non-compliance for 6 years, and perhaps it's even defiance. Thank you.
Thank you.
Do you folks need to see anything on there that, because it's bigger than what you have, or is it adequate? I can just unplug.
I can see it pretty clearly in your packet.
Okay, thank you very much.
you.
Any questions?
I don't have any. You all set? Okay.
Oh, Stephanie, I'll take care of this better later.
Brandy, did you want to speak? Who's not? All right. Does someone want to read? We have some correspondence. I'd
I'll
like
read it
somebody
if
else
you
to read it.
We have a letter from the Carroll Living Trust, Arthur and Adele Carroll of 1409 Slybrook Road, Eagle Lake, Maine, addressed to the Limerick Planning Board, Limerick Municipal Building, 55 Washington Street, Limerick, March 18th, 2026. Dear Planning Board members, we continue to have serious concerns due to the environmental hazards that our property abutting CIA Salvage's junkyard is being exposed to on 41 Range E Road. Why isn't the Planning Board requiring test wells around the edges to assure us that contaminants aren't poisoning our land or our groundwater? The fill material that the Gerards have used to cover the bedrock is not preventing leachate from traveling down to the bedrock and downslope to our property. Where is the erosion control that was required to prevent surface water from going downslope to our property? Why is there no vegetative fence to screen this unsightly scene from destroying the potential use of our property? We are the losers and the Gerards are the beneficiaries of this environmental disaster bordering our property. We deserve better than what is occurring and we demand accountability. It's time for the town planning board to protect the abutters. From Arthur G. Carroll and Adele L. Carroll, D.O.
Is there anyone else? Like, Stan, would you like to speak, or you want to wait till after? Do we want to give Sean a chance to speak now, or do we want to wait until after and do it during deliberation?
Doesn't matter to me.
Speak now, this way we have some more information.
All right, you're welcome to rebut or speak on Sean's behalf.
I'm not sure whether this is appropriate for the public hearing phase or for the deliberation phase, but rather than get shut out, I'll take this opportunity. For the record, my name is David Ordway. I am the attorney for CIA, Sean and Dennis Gerard. I have been coming to these meetings both for CIA on Route 5 and Range Road for the better part of the last 20 years, I would say. I would thank Dr. Farron for quoting me and agree that you are being asked to make a decision that has to be documented based on probative evidence, valid evidence, and not conjecture and speculation. As a starting point, I only have 3 copies of this, but I made a chart that tracks the history of the permitting of the conditional use permit on Range Road. As Dr. Farron noted, the first conditional use permit for Range Road was granted in 2020. It was all of the conditions contained in the conditional use part of the ordinance, together with all of the conditions contained in Article 6, Section E, which applies to junkyards and salvage yards, were satisfied when that permit was issued. In 2022, the conditional use permit came for renewal. And in that year, conditions 2, 3, 6, 9, and 13 were deemed not satisfied by the planning board. In November of 2022, the Zoning Board of Appeals reversed the decision of the planning board and directed the planning board to issue the conditional use permit. In 2023, over a course of many months, the planning board again took up the renewal of CIA's conditional use application, and in 2023 determined that 12 out of the 16 conditions contained in the conditional use standards had been met, but found that condition number 2, condition number 6, condition number 9, and condition 13, and condition 16 had not been satisfied. In that case, in March of 2024, the Zoning Board of Appeals reversed the determination of the planning board and again ordered that the conditional use permit be granted. Now, it's a little bit of a sore subject to be brought up, but at the board's meeting on November 5th, 2025, about 3/4 of the way through the meeting, after regular business had been taken care of, the chair brought up the matter of CIA's application. There were 3 members of the board here at that meeting, and Stan was not here. CIA was not on the agenda. No one from CIA was present at that time. But nevertheless, the chairman said we need to do something about the scheduling of CIA's application. If he had left it at that, it would have been fine. However, the discussion then proceeded into a 15-minute discussion about CIA and what's to be done with the application. For the record, I will add a transcript of that proceeding, if you wish to review it. What was most disturbing about that conversation, in addition to the fact that the chair allowed Dr. Farron to get up, speak, and participate in the discussion, were statements made by the chair questioning or saying quite emphatically that CIA's application should be denied. I won't cite all of them, but one that jumped out at me was the chair said, "We have a huge amount of evidence that the conditions are not met, so we certainly can't go forward and approve it knowing that there are those violations."
Do you have a date of this again?
November 5th.
Of what year?
Last year.
And if you have any questions about being misquoted, the link is still available at SRCM Town of Limerick, the YouTube video of that meeting. For all practical purposes, CIA's application had been decided before that meeting ended. Based on my review of the discussions that took place, I came away from watching that video with the distinct impression that the chair believed, anyway, that the decision that the planning board had made in December 6 of 2023 was somehow still in play. While it's true that all of the conditions, the 12 conditions that the board deemed to have been satisfied, were left undisturbed by the Zoning Board of Appeals and were not overturned by the court, the findings you made on conditions 2, 6, 9, and 13, as well as the special finding regarding screening, were all overturned by the ZBA. Indeed, the court's ruling that the findings you did make were not adequate for judicial review. So let me be plain in terms of all that Dr. Farron spoke about in terms of violating this condition or that condition, that CI hasn't done this and hasn't done that. Those conditions do not exist for those who have not taken part in this odyssey over the last 10 years or more. There have been a series of denials, a series of appeals, and the decision that in 2023 made by this board, reviewed by the Zoning Board of Appeals in 2024, that decision of the Zoning Board of Appeals is the last decision standing. I emphasize that because there were some very detailed findings that were made by the Zoning Board of Appeals when it reviewed this planning board's last decision. And
Do you have those in the minutes?
what's that?
Do you have the minutes of the appeals board meeting?
Of the appeals board meeting, I have.
They have they
I-
usually have very detailed minutes.
I have the decision, and I'm going to read it. I'm going to read it to you. How's that? Among the findings that the Zoning Board of Appeals made, the planning board did, as a matter of law, exceed its authority in reviewing the renewal application. Instead of doing so, the planning board effectively conducted a new review of the entire application and required CIA Salvage to prove compliance with each standard anew. This far exceeded the appropriate scope of review under the ordinance and forms the basis of the ZBA's ultimate vacation of the planning board's decision. With respect to each one of the findings, with respect to number 2, where the planning board had made the finding that the use of the property, that Dennis Gerard goes in and out of there almost every day to go play with his toys in the barn. The use of the property is going to create a hazard due to noise, dust, fumes, and the like. That was the finding made by the planning board. The ZBA said, the ZBA heard argument indicating the conditions on the property had not significantly changed between the issuance of the permit in 2020 and CIA's renewal application to justify an inverse finding. The ZBA heard argument from the planning board chair regarding concerns by abutting property owners. However, the ZBA does not agree that the raising of such concerns is sufficient legal grounds to justify this result. Moreover, the ZBA agrees with CIA Salvage's argument that contrary to the planning board's findings in this regard, the lack of supporters for a project is not a legally justifiable ground to make an adverse finding. Going on to the question regarding buffers. ZBA found the administrative record does not indicate any change in conditions on the property that would require additional buffering, which would be within the planning board's review as part of a renewal application. Moreover, importantly, and I'm looking over there, if violation of the original permit were identified, it is within the code enforcement officer's jurisdiction to enforce such violation, not the planning board's. Then my favorite was the board made a decision regarding significant scenic vistas and found that CIA's use of the property threatened significant scenic vistas. If you look at the chart in 2022, the board had no issue with significant scenic vistas. But as if some scenic vista emerged out of the ground between 2022 and 2023, the board found that CIA's threatened significant scenic vista. The planning board observed the intent of this standard is to prevent a conditional use from blocking dramatic natural views such as the Limerick overlook. Without further definition, it cannot possibly be the case that this standard was intended to apply to views of the subject property rather than a view from the subject property. Because the planning board could not indicate any such view other than the subject property that was impacted by the use, the planning board erred. Continuing, regarding erosion and sedimentation control, the planning board concluded that the administrative record does not support a finding that the layout of the property, the type or intensity of use of the property, or the arrangement of natural features on the property have changed to the point where the conclusions of Stillwater would no longer be valid. Finally, regarding the buffer requirements imposed by the board, and most of the discussion here has been with the buffering and the fences and the number of shrubs. Article 7G3, and this is, I'm quoting the zoning board, does not include any of these requirements demanded by the planning board. The ordinance does not prescribe a set number of trees within a vegetative buffer. The relevant section only requires the mature height of the vegetative buffer, not the planted height, be 15 feet. Moreover, the 2020 permit does not adequately describe the exact placement or required fencing. It is legally impermissible for the planning board to now deny the renewal application as a result. In the meeting that took place at the tail end of the November 5th meeting, there was much talk about having hundreds of violations and plenty of evidence that violations have occurred. That violations tossed around is easy enough to say, but there are many requirements for a violation. Requirement number one is that the code enforcement officer furnishes a property owner with a notice saying, I have reason to believe that a violation has occurred. And the property owner must be given an opportunity to be heard, and the code enforcement officer will then consider whether the alleged violation is sufficient to issue a notice of violation. If he determines that, then he must furnish a detailed notice of violation and outline all of the reasons for the violation. He must also notify the property owner that the property owner has the opportunity to appeal that decision. When all appeals have been exhausted, then that notice of violation becomes a violation. It is not a violation because Dr. Farron pronounces it to be a violation. It is not a violation because the chair thinks it's a violation. It is a violation when it has gone through the process. This board is not made up of private investigators.
I'm going to stop you there. I think you're getting kind of a little bit off track here. I think this board was set up with lay people, and these lay people may have expertises in certain areas. And what you're saying, I don't follow that at all, because that's not what. Sit down. You don't have the floor. You don't have the floor. Sit.
If you're going to let Farron speak all his crap, and you let somebody else speak theirs.
I'm speaking right now. Yep. Our lawyer, when we had a lawyer, said that we are the ones who make the decisions. We are the ones that evaluate the facts, and we make the decisions. We don't have to be an expert. We have the right to weigh our own information and what we hear from the public, what we see on the site. We have that right. We have been given that right by the voters. So what you're saying is not true, We have that right, and we have the right to make those decisions, and what you're saying is completely false.
And your decision is reviewable.
Absolutely.
You are,
Absolutely is
you in particular are not to be sitting in judgment on this case.
I don't believe it.
But because yours is not the final word. A decision from the planning board first goes to the zoning board of appeals.
That's correct.
The zoning board of appeals wrote a very detailed decision. It is clear to me that it was written by the town attorney, and for all of the findings that you made, the findings that you relied upon to deny a conditional use permit to CIA were all reversed. As a matter of law, this planning board had the opportunity to appeal the ZBA's decision.
And if
The
you-
town
if
of,
if-
no, you
if
listen,
If you
you
listen to me
me.
for a second, you can actually see in these minutes that you handed out that I said, I don't believe that the outcome will change, and it will cost the taxpayers lots and lots of money, so I do not believe in one board fighting another board. That's what's said in these minutes. As I said, it is not worth the fight. I think it is not correct, but I don't think it's proper for one board to fight another board.
Well, you're also the one who held for 5 months refusing to sign CIA's conditional use application because you didn't think your decision should have been reversed. So it's, let's tell the whole story when we tell it.
The
ZBA made
the
I'm
amendments to the
sorry.
conditions,
Pardon me?
the final amendment to the conditions in which we're supposed to be met were agreed upon after all of this happened. So regardless of what all these decisions are, they are irrelevant because they are prior to the decision made in agreement by Sean and this board of what those conditions are going to be to issue the latest permit.
Which conditions were you talking about?
The conditions for the border, the conditions for the conditional use permit, in which we submitted 10 amendments saying that Sean will do these things in order for the permit to be issued. We all agreed on that post-ZBA agreement. So regardless of what their decisions were, we all came to another agreement in which the conditional use was issued.
The conditional use, the decision of this board was in December of 2024.
Right, and then it went to the zoning board of appeals, and then it came back to us.
Oh, no, that's not correct. What happened was that after the zoning board of appeals made its decision, neither the town nor this board appealed that decision. That became the town's decision. Dr. Farron then appealed to the Superior Court. The Superior Court reviewed the record that he had submitted and said, this record is inadequate for judicial review.
They said the record of the site walk was
No,
inadequate.
he said the record on appeal is inadequate for judicial review. And he said, I will send it back to give you a chance to try to make it adequate for my review. It came back, and you had basically a third attorney come in to sanitize, to clean up, to go through those findings and to try to make them adequate for judicial review. I thought all they did was put polish on the findings that were already inadequate before they ever went back to the judge. Dr. Farron and the town filed a voluntary dismissal of the appeal. The effect of that voluntary dismissal of the appeal was to leave standing the decision of the Zoning Board of Appeals. Just to be clear, the decision of the Zoning Board of Appeals was that CIA, that the 12 conditions that the planning board had already agreed had been satisfied. They left those intact, and they reversed the other findings made by the board and explained, that's what I read to you, was their explanation of why they reversed it. So that as of March of 2024, the planning board ordered that CIA's conditional use permit be issued without conditions.
I thought we have the conditions for the berm, for the fence. Don't we have like 10 conditions that were part of an amendment?
That wasn't our amendment.
No. And
So what-
basically, what the board was saying is that, or what the zoning board was saying was that on a renewal application, unless you find significant changes in the use that is being made of the property or the way it is being used, that the original conditional use application still applies. And their criticism was of the 2023 application was that it was opened up as if it was a brand-new permit without any regard to the fact that it was an existing permit. So Sean, nevertheless, he was not, and I told him my opinion was that all of these conditions that you've been talking about, or Dr. Farron's been talking about tonight, did not apply to his 2023 conditional use permit. Nevertheless, consistent with his agreement with Dr. Farron, which is none of your affair, and consistent with discussions, multiple discussions that he had with Stan, he did considerable amount of work there, planted, what, over 600, over the last 400 or 500 trees. Even if you compare the aerial views from 2020 to 2025, I was actually quite impressed with those, that it seemed that the whole area not only was cleaner, but had become smaller.
So you'd be okay with having your house right next door to that? You'd have your well and drink your water, and you'd have a house right next to that? You'd love that? You'd really like to have your house next to that mess?
Well, I probably wouldn't want to have it next to a quarry and gravel operation over here either. But I would expect nothing less from you, who've already expressed your bias. A lot of this, and a lot of what I heard from Dr. Farron sounded like he was bad-mouthing Stan. I would ask Stan at least to confirm that there are no present outstanding violations with respect to Range Road, that any reasons that he had to believe that violations had occurred, he investigated them, that he spoke with Sean, he made recommendations, and for the most part, Sean was compliant with your request. Is that fair to say? So we're still...
Just a moment. Stan, for the record, you say there's no violations on that site today?
There are no violations that I can issue an NOV on and stand behind in a court of law. The basis of the findings of fact, again, repeatedly have been said they are unclear. and they're open-ended. And part of the conditional use was conditions of approval that need to be met within a 2-year period. So we get to the 2 years, and then again, you give them another 2 years. So there is no violation that I can issue that will stand in court, all right? I have talked to Sean, and I have kept the planning board, the select board, and Sean, and DEP, and Merrill all in the loop when I've had a concern. I share the pictures, I share my opinions. I talked to Sean, especially about erosion control. Sean did put bales of hay up last fall to minimize it so that when he got back to it after the ground froze and you can't do anything. So again, Sean has made efforts to improve it. He's made efforts to accommodate Merrill's concerns. The fire chief and I went and walked there with Sean after Merrill's visit. The fire chief found no problems in the rear of the building as far as he was concerned in a fire lane. My opinion, there needs to be a fire lane, right? My biggest complaint with Sean, and it's been expressed that with DEP and with the boards, he's got atrocious housekeeping habits, all right? So it is hard to maintain because he's been trying to get to the 2-to-1 berm, which he did accomplish, and then he started filling in the front end of the property, which I've discussed with Sean as well, is a concern because you're raising the elevation in stormwater runoff, right? The piles of lumber that I consider is not usable, he did say that he was going to remove it, and when we walked there today, it had increased in size. So I'm assuming that, and I have not talked to him yet, but I'm assuming he's starting to clean up his yard. So again, right now, there is no violation that I can write and stand in court. I do put them in writing, and I do express that with the planning board, and I do express it with Merrill and with Sean. But I got to, before I write an NOV, as Sean's lawyer said, you got to be able to stand up in court, and we can't. Otherwise, it's useless. And I did have written them before with the select board, and the select board wouldn't stand behind them. So I need to make sure that when I do that, I have adequate ammunition and facts that I'm going to win in court, or I'm just going to be spending town money. When I go to court, I get my money back. If I lose, I don't. So again, I'm not going to go there until we have something more solid. And Sean, realistically, at this point, when it started in 2019, the code enforcement officer, again, followed a pursuit on a complaint and called it a junkyard. Well, a junkyard has a wide, broad definition under the state of Maine. It can be a nuisance, it can be a pile of trash bags, okay? But the junkyard, in essence, Sean doesn't have a junkyard. The building materials, there are some that are not usable and are scrap. He needs to dispose of those, but again, that doesn't qualify as a junkyard. Automobile graveyard or recycling, he doesn't have an automobile graveyard because he has antique vehicles. The law does say that if he wants to keep them, he needs to register them or keep them inside. So those are the criterias. But because the town took the stance and prohibited any junkyard or automobile graveyard, they created a non-enforceable situation. There are a lot of people with automobile graveyards with 3 or more vehicles that are unregistered. There are many people with a lot of washing machines and other things in their yards. There is no way one individual or even 5 individuals in this town could enforce them all.
So,
There just isn't.
So Stan,
So-
a junkyard by state ordinance is a yard, field, or other outside area used to store, dismantle, or otherwise handle. A, discarded, worn out, junked plumbing, heating supplies, electronic or industrial equipment, household appliances, or furniture. B, discarded scrap and junked lumber. C, old scrap copper, brass, rope, rags, batteries, paper trash, rubber debris, waste, and all scrap iron, steel and other scrap and not ferrous and non-ferrous material. Is that not a junkyard?
It is, most of his materials there, the metal stuff is usually staging and other stuff that he's using for buildings.
Scrap and junk lumber,
The
so,
scrap and junk I just mentioned, he is going through and he needs to remove that.
so I mean, that's why he has a junkyard license, a junkyard permit, and an automobile graveyard permit. That's why he has what he has there.
That isn't why originally Mike Gilpatrick brought that up to you in 2019. That is
Well,
not.
it was originally because of the building materials. That was the original reason
Yeah,
for,
but building materials does not qualify as a junkyard.
discarded scrap or junk lumber. So that,
And did you see discarded and junk lumber
absolutely,
there in
absolutely,
2019?
absolutely. Absolutely, there's a lot of discarded and junk
I
lumber
have
there.
nothing in the file that proves that. I have no pictures, no written documents, nothing. Okay?
Okay,
So, again, if your findings of fact are loose and not precise, that is what the judge came back and told you too. So I have nothing I can write.
I'd say 50% of that lumber is usable at best.
And again,
I hear what you're saying, Stan. In 2019, we have no evidence of that.
Yeah.
But today, there is a significant amount of junk lumber. There is plumbing piping stacked up behind the building.
The plumbing materials are not scrap. That is stuff he is saving for his buildings.
Okay.
Again.
But there is scrap metal all throughout the dirt there. There's iron pipes sticking out of the ground. There's rusted saw blades in the ground. There is junked material there.
You saw that tonight.
Yes,
'Cause I did
definitely
not
there,
see that.
sticking out of the, I mean, it was in,
Right.
we both
So-
kicked a saw blade that was rusted. There were iron pipes sticking out of the ground. Rebar, all through that area where he has increased the grade since his original permit was issued.
So rebar is construction material. So,
Okay.
Yeah, I mean, we're agreeing it's a junkyard, and he has a conditional use permit for it.
There was some talk that it was not a junkyard, and I want to make sure that it's absolutely a junkyard and an automobile salvage yard, automobile
but
graveyard.
it is not an automobile graveyard. He's fighting for it because, again, the town took a stance.
So what do we, so it's only a junkyard, it's not an automobile graveyard?
No, and Allison from DEP
Okay.
told you the same thing.
Okay, all
He's
right.
allowed to have 9 vehicles there. They're antique vehicles.
So it's only a junkyard, not a salvage yard, not an automobile graveyard, salvage
And
yard.
the scrap debris was the cleanup he did to appease Merrill Ferran, and he started cleaning up the back of the property. Now, he's just coming off in the winter months. So other than that, you got building materials. Allison Moody has walked that property many times. I have with DEP. They just recently walked that property, and they actually wrote in there they found no problems. So again, but getting back to Merrill saying that he has told me to write violations, I cannot write a violation based on what I have. And if any one of you think you can do it, then do it. Because you're not going to stand in court and you won't win. You'll end up costing this town another $10,000, all right? And you can listen to Merrill all you want. That is up to you. Merrill is Merrill. He's an abutter. He has a lot of valuable points. But nobody is supposed to lead the review board, and nobody on that board is supposed to lead the board. You are to review, if you go through the trainings, the materials presented to you. If you don't have something you asked for, then it's a denial. Those are your options. And a renewal, Natalie said in 2020, it is not a new application. You need to develop rules based on what a renewal is, and the planning board has failed to do that.
So in
And
your
based on
opinion-
that, I'm saying goodnight. You guys do this. This is why Mike Gilpatrick walked away, because the planning board is not doing what they're supposed to do.
In your opinion, hold on, I have a question,
No,
Stan.
those are facts, I'm done. I'm
Okay,
done.
so you're just going to walk away?
Yes, I am.
We have questions for you.
Well-
You made statements up there.
You've already made your decision.
No, we haven't made our decision.
November 11th, we watched, yes, we did. You said he was in violation, he did not.
All right, bye, Stan. Fucking useless.
All right.
Can I address any of your questions?
No, you can't, because he made a statement about why he felt like he couldn't legally write a violation. I wanted information on why he felt he couldn't legally write a violation. You can't answer that question.
So I guess, I hate to allow you another minute, but I'm gonna give you, I'm just gonna give you a minute, I guess.
I'm not going to argue anything that Stan has told me. What I'm going to say is, if you look in your manual tells you, if a prior board has made a decision in error, you're welcome to move forward if you have the proper evidence to do things that you feel are right. I don't know how I heard what I just heard, so I'm not even going to approach it. It was Stan himself who told me the 2020 permit is the one that is being used. My details were based upon that information. But more important, you're allowed to open anything you want in regards to this stuff. If you think there is an error made in the past, and ensure that if you're following the letter of your original intent, you're just making it stronger. To me, it sounds like law is on your side. Thank you.
I will take my opportunity for rebuttal. Dr. Farron may have been a very fine doctor, but he only pretends to be a lawyer. This case is governed by what the law calls res judicata. That's Latin for, it means the thing has been decided. You do not get to take a second, third, or fourth bite of the apple every 2 years when there is a renewal application in front of you. There is an appeals process. It goes to the Zoning Board of Appeals. From there, it goes on an 80B appeal to the Superior Court. From there, it goes to the law court.
why would the voters of this town give us the opportunity to review this every 2 years to make sure that the applicant is doing what they're supposed to do and the property is not causing environmental hazards and it's not causing erosion? They gave us 16 things. Actually, they gave us 20 things to look at and make sure that this applicant is doing his job.
You can ask Natalie Burns, who was one of the finest land use zoning lawyers in the state of Maine. You can ask Mr. Attorney Brandywine. They already told you. You know what the answer is. They told you what the scope of your review was.
That's not what Zach told us at all. That is not what.
You refuse to accept it. You refuse to accept the decision of the Zoning Board of Appeals. There has been not one court decision that has supported a decision of the Planning Board. The reason why you don't get to do it every 2 years or every 3 years is that the composition of this board changes, with the exception of you, who seems to have been here as long as I've been coming here, and that you don't, a landowner, whether it's CIA or anybody else asking for a conditional use permit, does not have to reprove their case every 2 years. That if there is a violation, that is the business of your code enforcement officer, not your planning board. And I know you don't accept that. That is the law. That your review
That's not what our lawyer told us. And so I think you have a very nice opinion, but I don't share it. So thank you.
Well, I know you don't. I know you don't
Thank you.
care.
Yeah.
And so I will just formalize.
I didn't say I didn't care. I said I
will
do.
formalize the request that you not vote on this application based on your conflict of interest and based on the way you conducted the meeting on November 5th.
Okay, and we'll vote on that, just so the board can vote on it. If they want me out, that's fine. Anything else? Okay, with that, we'll close the public hearing. Okay. I am not prepared to move forward with any, anything on this tonight. I don't know if the rest of the board wishes to, or,
I'd like to get a copy of the original permit so we can take a look at it. If that's what we're gonna be held to, and I'm not
Okay.
sure I totally agree with that, I'd like to get a copy of it again and review the original findings of fact.
that was,
You're asking for the approved conditional use permit.
Yeah,
The
with the
one
findings
that,
of
the one
fact.
that we're operating from, to say this is what you're trying to renew. That one exists from 2020.
Or whatever, whatever we're
what is the
being-
one that you gave us tonight?
That was the one that we redid, that was never sent back to the
Oh,
board.
okay, all right. So that's not the, I believe so, yeah. Yeah. The 2020 decision is I believe that's the original decision.
Why only two signatures? That's not quorum.
Yeah, because I wouldn't sign it. I believe.
What about the other two?
I don't know. And Wendy wasn't here, and I don't know what about, Ed had resigned at that point, so. I don't know. So anyway, I think we should all look through this decision. So make us copies. Can you also send it out to us, to the board?
Can I be furnished with copies so I know what's going into the record?
Yes. So, I guess one thing I'd like to do tonight before we leave, before we end the meeting, is just do a little bit of a recap of the site walk, so we have that into the record. So the site walk was attended by Ashley, myself, Peter, and Brian from the board. In attendance was Sean, Stan, John Medici,
Dennis.
and Dennis Gerard. And Merrill, of course, you were there. Okay, yes, okay. We did a perimeter walk, basically around the perimeter, looking at the slope on the westerly side. We weaved our way through the middle, walked to the back, and looked at some area where some filling had occurred. We walked along the Brulot side where we discussed sloping on that side. We kind of looped back around, came in around behind the building, and then we walked in front of the building, and then Sean showed us in the building. Nothing really of note inside. There was Sean's father's hobby stuff inside, so nothing, I was never saying that there was anything inside there. I just had no idea. So this is the first time Sean has ever opened it up for us to go in and see, so we did see what was in there. We walked out by the street, out by the gate, I guess, and there were some questions about the side lot and how that pertained to this, and Stan answered some questions from Merrill. Did I leave anything out that?
Yeah, there was a large discussion out back about the timing of when that area was, the grade was in, like this elevation in the back, I guess it would be the northeastern corner, was pushed out. I mean, we saw that the last time we were there for a site walk. I don't think it's been modified since then, but I believe that's happened since 2020.
Okay. Anything else you want to add, Ashley?
In the minutes of that March meeting, it might have been 23, Sean, you did agree to the 2-to-1 slope.
Well, we talked about the sloping and all of that, Mr. Carroll wanted 2-to-1 slope. We currently had 1.7 on the Carroll side.
On the opposite side is what I'm talking about.
On the Carroll side of the property.
I'm talking the opposite side.
Yes,
Yeah.
all right, so that's Mr. Bulat's. There was no mention of any 1 point.
There was,
We
in-
put it in and you guys approved it.
you spoke in the minutes agreeing to the 2-to-1 slope.
You have to watch the tape and make sure it's real, because around here you can get anything you want with the piece of paper. But there was, let me say this, if Mr. Bulat's side was illegal or wrong, wouldn't the board have addressed it then? They didn't care what Mr. Bulat had. Mr. Bulat wanted a high banking, and we did that, and then we planted trees and everything else in it. This board approved that. There was no talk about 1.2 or
I think-
2-to-1 slope or any of that.
It was definitely discussed, and we actually added some sort of an amendment to the condition where we allowed you to put that berm along the side.
Yeah?
And what we said that it would be 2-to-1, and it would be treed, and
We're not talking about-
in that amendment. And at that time, we had not thought that you were going to backfill up against it, and that is something that has
What we
changed.
thought and what we did,
That is
what we got approved, I have a letter here dated April 5th, 2023, to whom it may concern, I, Corey Bulat, my family and I built and ran construction company out of 41 Range Road. The property building was sold to CIA Salvage. I am aware of their operations for storage, machine shop, and whatever CIA runs, junkyard, graveyard. I have no complaints with CIA's operations at this time or in the past. I am a butter on the northeast side of the property. There is at least 50 feet of growth between me and the trees between us. I see no reason for more of a shield. The town should require additional screening. I prefer an earth berm to a fence. And I can be of assistance, please contact me. And that was signed before the board, notarized by Diane Danis, a paralegal.
Yes,
And-
and we,
In the March 20th, 2024 meetings, Sean got up and approached Aaron with what appeared to be a plan and went over the area abutting the brulette, stating the berm would be a 2-to-1 slope. If there was no berm, they would plant trees. Sean continued what appeared to be around the property, stating a 2-to-1 slope. Some area he pointed out that he would have saplings, and another area would be 70 trees.
The
Then he
only
got out a
area that
large
was-
plan.
2-to-1 slope was on the Carroll side of the property.
This specifically says the brulette.
You guys approved it. I mean, how, if it was, if it wasn't a 2-to-1 slope, how could you guys approve it in the last conditional use permit? You know,
we didn't. We didn't approve that.
you didn't, you
we
didn't,
we
you didn't
didn't- we
fail it
didn't-
for
we-
that either.
Yeah, we did. We failed it for not meeting the 2-to-1 slope, and the appeals board overturned it. We'll let the appeals board merits be on their own. So anyway, I just want to make sure that we have adequate notes of the site walk. And so if there's anything else to add, or if Sean wants to add anything about anything that was discussed at the site walk.
You know, you guys did the sidewalk, said you found a few things here and there. I haven't been there, we've had snow all winter, so there's different things that you're gonna find in the yard for what stuff we bring in. I mean, we recycle all the metal we bring in, it doesn't go buried out back in the yard. We don't bury anything out there. The only thing that's got there is we got rid of the concrete, because Merrill was complaining about the concrete bunkers. So that's what is in there. Anything that's there for metal, we pick up. Anything that's trash, we have a dumpster. We have our own roll-offs. So as soon as we get things cleaned up, now that I'm divorced, I can clean up whatever's gotta be gone, whatever the wood that's not usable goes. And I'd like the board to decide if we're gonna vote for Mr. Carroll, to be recused or whatever we wanna call it. Because he
Okay.
clearly needs to.
Okay. That's
One
fine.
last thing before that, the gooseneck trailer on the left side of the property at the front there.
The right side of the property?
I'm sorry, misspoke, the right side of the property. As we mentioned, is on the rangy, or the 41 property. That gooseneck trailer is supposed to be 100 feet back.
It's a registered trailer.
Equipment for the salvage, or for the junkyard.
You're just saying that was part of the discussion
Yep.
at the sidewalk.
Yep.
It's a registered
All
trailer.
he's saying is that was part of the discussion that was there, and I don't really want to get into the merits of it tonight.
That's this?
It's a registered trailer,
Okay?
and you can put it anywhere. You can put it in your driveway. I have an agreement with Merrill that I will keep the front yard clean, and that's, so, but that is a separate deed, separate lot, a separate property.
Okay, so what we're actually saying is, or what I believe Merrill was trying to say is that 41 Rangy does actually go around that property and then go around the schoolhouse lot and then come back around. So it technically does touch Range Road.
Makes a U.
So he is correct that it touches it. Are we concerned about that? I don't know. I don't see that being a huge
It
deal.
does touch it, but on the other note, we're not surveyed, so we don't know, Merrill's not a survey. He doesn't know exactly what the setback is. And that's what we went through hundreds of times with the schoolhouse when we had that approved and we got a building permit for it. And then we didn't build because of my divorce, and then we let it go. So there has been a building permit issued on that. The foundation is there. It's exactly where we say it was and where the survey said it was. Merrill says it's a different location. But Merrill's not a surveyor, so he's not gonna come to my yard and survey my lot either.
So what I would like to say to you, Sean, is from the very beginning, I have told you that I'm okay with if you wanted to have just what you had there. From the very beginning, that's what I said.
But
That,
what you don't-
just a minute, if you could listen to me. I said, if all you want is to be able to have a place for your dad to go and work and do his work and have a spot to put some lumber so you can build houses and a few cars, I'm fine with that. What I do not want to see is to have mini CIA move over there. Okay, that's all I've always told you. And
Yes, you have.
so
Can I talk?
I would just like to
I
talk,
understand
I would
what
just
you
like to
want,
talk, I don't want to go back to lawyers, but I feel like I'm right on that edge right now of wanting to hire a lawyer.
Okay.
So
And-
what I would like to see, so this is me. What I would like to see is I would like to see you do some work on that other side and try to straighten that up.
On what side?
On the Brulot side. Try to make that more of a 2-to-1 slope. Get away from
Kill
those.
all the trees I just planted.
So if you could listen to me for just a minute and not talk, that's what I would like to see. I would like to see you clean that up on that side. I would like to see you work on some housekeeping, getting some fire roads in there, doing a better job with that. I would like to see that, it's housekeeping and the fire, making sure there are fire lanes, protect the fire. I don't want to see you keep adding on to this property. Keep adding on and moving forward, without consulting Stan. So
I consult Stan every week. Stan
okay,
and I
so
talk every day.
I would like to see from the back of the building be the end of this property, end of this junkyard. Nothing goes beyond that. Everything stays where it is or ahead of the building. We do our best to screen the sides, the side being, well, both sides actually, try to do our best to screen both sides.
The Carroll side is.
Whether it be a berm or trees or a fence, protect the neighbors. So
Protect the neighbors here.
I don't feel that, I don't feel that that's true. And so,
Can I have a minute now?
just a second. So I don't want to spend another year arguing over this. I want to see you get this permit. I want to see you succeed here. What I do not want to see is an absolute mess. Today I went there, it was worse than the last time I was there. And I didn't know that that could be possible, but it was a total mess, and I thought that you could do a lot better.
Okay.
Now, so can we come to some sort of agreement that you can do some of these things and get to a point where we're not arguing all the time? I'm really tired of arguing with you, and I'd like to get to some sort of agreement so we can get some of this stuff done and cleaned
Let's
up.
talk about the Carroll side of the property. It's a 2-to-1 slope. It was a 1.7. We had a whole fence down there that you couldn't see in. They planted with trees. Mr. Carroll wasn't happy, so we took all that down. That's what you see, the metal in the yard that was there, the green metal in the post. That's all gonna get cleaned up, but we didn't get it done in the fall. So that side there is all done. 2-to-1 slope. Front yard's all 2-to-1 slope. Boulevard side's 2-to-1 slope. I don't know exactly what the slope is on the other side, but it's what Mr. Boulevard wanted. That's what we discussed.
Okay, so what I'm asking for you to do is to bring that back up to 2-to-1 on the Brulot side.
Why can't we leave it what Mr. Boulevard wanted?
So that's what I'm asking you to try to get that cleaned up on that side, get that cleaned back up.
But you're gonna kill 300 trees that we planted in there, Aaron.
They're just little trees. It's not gonna take much of a little shovel to scoop them out, okay? I understand that. That's not a real big deal. You need to stay out of that 60-foot setback. You need to stay out of the 50-foot setback.
Yeah, and
I'd like for you to just step back for a second and say, wow, I can really see a lot of stuff on top of that hill. Is my screening really adequate? Okay, that's what I would like you to think in your head, not the Carrolls are jerks. Just, if my house was here and I was looking at this, I really wouldn't want to see all that stuff, would I? Okay, so if you could, so
we would have made compromise on the 1.7
so
to the 2-to-1.
So Sean, what I'm saying is, there was a reason we wanted that slope, so that we could try to protect the water going off that property against the boundary line.
Okay, so
That-
everything,
so-
can I have a second? Everything is 2-to-1 except for on the Boulevard side. I would like to leave the Boulevard side so we don't have to dig into that and upset him. Out front, my goal was to take and do the 2-to-1 slope out front between me and your uncle. Clean that up, put in the recommended detention pond, or not, the settlement pond that my engineer recommended. Him and I talked about that. That's $10,000 that we recommended. It's not something that needed to be approved by you guys or we asked you to do. It's a $10,000 bill that we get because we want to make sure that our water doesn't run on your uncle's land. And there's no contaminants there. There's 9 cars there that have already been drained. So, unless you get a contaminate from a piece of wood. So we want to continue to clean up the front yard. I have an agreement with Merrill that we won't put anything in there. And I have my watchdog, the Grinch, watching out for me. And so we're going to continue to fill that in. I even went as far as being accused of hauling dirty dirt in there. So I turned around and I went to the Eastern Earthworks, Robbie, and I asked him, can you give me a letter where that dirt came from that you hauled me? And so he supplied that to Stan from the locations where it was, and he says there's no dirty dirt. I've been accused of that. I'm not going to take something from one place to another. It's easier just to pay Waste Management, bury it. That's what we did years ago, and there's no reason to take dirty dirt from one place to put it to the other. We want to finish up the front yard, landscape that, either put some trees or a fence or whatever we want to do. There was nothing in the conditional use permit that says I couldn't finish filling that in. We don't want our water to go on the front yard to you. That's for sure. I don't want to listen to that. So the only issue we really have is Mr. Boulots.
Okay.
Clean
So-
up housekeeping.
So if you could go from the point where the berm ends
On which side, Aaron?
on Roulotte side to the back, and you could get that straightened out, so that was 2 to 1.
I can't get it to 2 to 1.
You can. You can.
You guys
I
approved that, Aaron.
I thought the 2 to 1 was a lot flatter than it is, and by actually looking, I think, you know, it's steeper than I thought. So 2 to 1 is definitely doable, and it's definitely doable in that area. So if you could make that area from the end of the berm out to where the fill stops, if you could get that to 2 to 1, you could do you could be compliant with SWEP, you could do some of the housekeeping and then try to do a little bit better job on the screenings. I feel like we can
We
get.
had awesome screening on your side.
I feel like we
And
can
then it got
get there.
taken
Now, I just want you to think about if I'm standing on the neighbor's property, and I don't care whether it's my uncle's side or whether it's the Roulotte side, and you look up at that, you say, would I want my own house to be looking at that? Okay, and I think that's a reasonable thing to look at.
I
Now,
don't disagree with you.
so,
but I think that
so
on
can
the
we
Roulotte
try to
side-
get there? That's all I'm trying to do. I'm trying to work with you. I do not want to spend thousands and thousands of dollars and months and months and months arguing. I think we're halfway there. I think you've done some things that have moved forward. I think you've
that
moved backwards in some.
Roulotte side was approved in the previous permit, and it was approved by this board. I think that we leave the Roulotte side, we clean up out front, we get that all down, the 2 to 1 slope there, 2 to 1 slope on the road, we put in the erosion control that we need with still water, and we clean up. And I don't think that's being unreasonable. You're gonna see some wood, that wood is, once we get rid of the wood that is rotted, then you're gonna get rid of enough to build 2 or 3 houses. That's all gonna go. So that area is gonna be all open.
Okay, so kind of my thought, and the board can feel how they want, but I feel as though the Roulotte side, at least from the berm edge to the back of the property where it's been filled, needs to be 2 to 1 and needs to be stabilized. And if,
It is stabilized, it is,
I don't believe it is. So that's my feeling. That's where I draw the line. I don't know where the rest of the board is, and that's for that for us to decide. But if you want my vote, that's what I'm asking for.
Can I ask just a question? This is a suggestion. I know that you spend enough time doing this, but whether to get a consensus in a workshop or some setting like that, a consensus as to your wish list. I will work with him and try to put the wish list together, and then start fresh so that we are not going through the conditions every 2 years and having differences there. If in a workshop you've got a wish list and a consensus of the board, and then I can work with Jared here to
Okay.
try to
All right.
meld those lists together.
Okay, so, Meryl, I'm going to give you one more chance.
I don't think Merrill should be,
I
I've
think,
heard enough of that.
I think we all have to get on kind of the same page in order to get through this, and we're trying.
Let him get along when he's.
We're all trying to get on the same page, Sean, and I'm doing my best to try to get there with you and try to get as much as I can accomplished for the people in the town. So, Meryl?
I recognize that a lot of people think this is me alone, but I get a lot of people talking to me and thanking me for representing the area, and I am not a single voice. This is 6 years, and I don't believe that a renewal is about continued negotiation. I think it's about, has he met criteria or has he not? How many more times will you do this renewal process and change it? and I think it's a fairly straightforward, are all these criteria met or are they not? Once you're sure you know what that permit is, and I'm not going to try to tell you, I did what Stan told me was the permit in my comparison. But this person has a track record, and everyone in this room knows it, of being, pushing to the limit, being defiant, and doing things only when it comes down to actually losing it. Mr. Ordway, a little while ago, was telling you how bad you guys were. If you tried to turn it down, you were going to lose. Now he's sitting here ready to negotiate with you because he knows he has weaknesses. I'm just surprised that there's discussion about, oh, okay, we'll give you another 2 years on this, because that's exactly what it's going to be. It's a 2-year renewal process. It can't be changed. That's the ordinance, unless you guys change it and it's voted on. So it's going to be coming back here in 2 years. I don't understand this.
So
You got a permit? I'm not going to ask you to have to explain yourself. I'm just going to say what I have to say, which is I've sat here, had the same complaints to you folks, and I'm saying it as a board, not as individuals, about this problem over and over again. Most of you don't drive by it very often. Most of you don't see it. You don't experience it. The rules are black and white. They are in that permit, and they're just not complied with. Why? How many more times is there going to be an opportunity, and how many more times are we going to risk harm to the local people near it? Because that's what a junkyard and automobile graveyard have. They have risk. Thank you.
Okay. So, I don't know what how the rest of the board feels, but I think we definitely need to set this aside for a little bit. I would like you guys to think about whether you want me to recuse myself, and my uncle owns property next to that property. I do not own property next to his property. That is not a conflict of interest. He is not in the constitutionality chart or whatever it is, that is not a conflict of interest. I do not have financial gain from that. So you are welcome to vote however you like, and I will do what the board decides. So
Do we need to take a vote on that?
we can do it now. We can do it next meeting.
Let's
We
see if we
can.
do it next meeting then.
I'd like you to think about that and whether you'd like me to do it, and however the vote goes, I'll honor that. But
I have a question. Was the reason Stan couldn't issue any notice of violations because we didn't set timelines within the conditions to be met? Because I know he kept saying he doesn't have the authority to do it because of how the plan decided. So is that part of the issue?
I think that's what I was trying to figure out. And I was trying to piece through the parts where it sounded like the conditions we set weren't actually in place because it's reverted back to the 2020. So I was trying to
Right.
figure out why the original permit, he felt like didn't have enough to stand up legally. I would like to understand that part in general. So
Same.
just so like we could get it cleaned up, everybody knows what their part of it is, and the agreements are very clear.
I think there seems to be a lack of clarity across 4 different parties between the board as a whole, Stan, Merrill, and Sean. I think we all want to be on the same page of what has to be done by when and whose job is whose.
that's right. And I think we need very specific timelines as to how these things are going to get accomplished, and in order to get to the end of it. So, let you guys think on that, I guess. I'd like to move through the rest of our agenda and hopefully finish up for the night. I've lost my agenda, though.
Here it is.
I'm sorry.
There's an agenda in here somewhere?
So, thank you. Do you need something else?
Yes, I got one more question. There's an agenda paperwork that I see. Right here.
Yes.
And it goes down, it says old business, new business minutes, and then it gets to correspondence. Why am I under violation notice for CIA salvage on Route 5? Why isn't somebody calling me and saying, hey, we're gonna discuss this tonight, and we'd like to know what's going on?
That's correspondence from Stan. I don't think we are discussing it. It's something
I've
we're,
been issued 3 violations, one for keeping my gate open, which I'm the only business in town that has a gate. And I can show you 20 pictures that I plan on bringing to the meeting of the planning board, the select board on the 6th. I was also issued a notice of violation that Stan is gonna supposedly rescind because I have been proven guilty without, the neighbor said they heard me in the yard. Well, Stan went back to 2024, and it says that I have a right to go in the yard, I have a right to be there, I have a right to work, I have a right to clean, I have a right to maintain equipment and drive in and out. But I do not have a right, other than, after my business hours, to bring in, as a public, I can't bring you in for business. So I've been, the violation says that I did that, and I did not. There's no proof of it. Limerick doesn't have a noise ordinance to say my truck came in and out and made a noise. But if we're gonna have this correspondence and stuff, and I'm on there, just like the November 5th, that was quite a meeting. If you're gonna talk about me, at least call me up and say, hey, Merrill's got a lot to say, the board's got a lot to say about you. Why don't you come down and listen to the shit?
I think that was,
Just the record that you received it.
Yeah. It was just this, I think he was just gonna bring to our attention that he had sent you this notice of violation of conditional use on March 18th, 2026.
so I think there's
Was
that,
that
and
the
there's also a DEP petroleum
Also, just.
management decision. I think that must be something to do with you, but, so,
The board, Stan doesn't have if we have a notice of complaint, which I think is what we should work on in town. If you have a notice of complaint, I come to you, I give you, Karen, I give you a notice of complaint. Here, I'm upset, Stan. I got a notice, your neighbor said you were out there making noise till 2 o'clock in the morning. Here's a notice of complaint. You go down, you see the board, you see somebody, you hash it out, and you say yes or no, I'm guilty or I'm not guilty. Stan goes into the notice of violation, which if he doesn't rescind it, the only way I can get rid of it is go to the appeals board. But the town of Limerick don't have a noise ordinance. I was not working down back. I was there moving some trucks around, and there was no noise, less noise than what's on the cars going by. But if I'm gonna be on the paperwork, just like November 5th, I would like to be notified that, there's a discussion down here, and we're gonna shoot the crap about you tonight, Sean, so come on down and listen to it.
okay. We'll do a better job on
And I
that.
look forward to this board coming to a resolution and trying to work out everything, and I appreciate all your time and efforts, and I'm sorry to drag you all through this. It doesn't need to be this way.
Okay, thank you.
Thank you.
So where are we with, says, this Washington Street duplexes? They've sent in information, or they haven't sent in any?
No, it's on hold.
Okay, so
Until we
that,
hear from them.
so it's complete, that one's completely on hold. Jeb Garish on hold, and findings of fact,
Garish is not going to do it. right
they're
now.
not gonna do anything right now? Okay,
He's not going to do it Saturday.
okay, all right, so, and then the findings of facts are pending?
Yeah, I wanted to do that, and if I just change the date, all
Yes.
the answers are from a different board.
Right, okay.
Do I do an addendum to it, to the findings, and reaffirm their findings?
I think we have to, I don't know how that works.
We should just go through it
Go through each condition?
and just vote on, and we don't have to do it tonight, but we should just make it clean and just
Okay.
go through it.
So, maybe that's what we'll do, I guess, is we will review that one more time and go through each condition. I was trying to make it simple and get through it, but I guess that's not how it happened, so.
Shouldn't take too long to do it, but
Nope.
it really wouldn't work if I just changed the dates.
So, on one other note, I was looking through some survey information, trying to figure out a boundary, and I came upon a subdivision plan. It was for, the little houses along, the peninsula on Secocas Lake. And it was a survey plan from not Dale Metcalf, but the Metcalf Land Surveying. And the applicant had put a little signature block on there for us to sign. And Cheryl and I had signed it. And basically, it looks like we signed a survey. So that was Cheryl Edgerly and I signed this. So it looks like we signed a survey. I've brought that to Stan's attention, and he has reached out to this person and has told them that they need to have a official survey to the board, and that is not valid, and that cannot be registered the way it is. So.
The radians, right? That's in there.
Watch it, behind you.
behind you.
Yep. Right behind you.
That thing's gonna get me.
I don't know their name, but anyway, that is something that we need to be very careful of. It's happened to the board in the past, and it happened to me. I should have known better. I don't know what I was even thinking that night in signing that, so.
Were you asked to sign it?
They presented it to us as though it was their subdivision plan
Okay,
as a final copy,
got it.
and we signed it as though it was a final copy, and it was actually somebody else's survey map,
Right,
and we just basically signed it.
got it.
So we never should have signed that. We never should have endorsed a survey plan. It should have been a subdivision plan, and I did not see that it did not say that. So
Okay.
that was an error on my part, and I was very upset that I had done that. So something that we should all be watching for. Sorry, so with that, I'll entertain a motion to adjourn.
Second?
All right, all in favor? Okay, thank you. Thank you, and have a good night.